Yeah, okay, listen, folks, hang on to your seats here because we're going to give you a lot of twists and turns. This is the greatest case. Jamie, that was my number one thing. That got my first holy cow as I literally was writing down that they were, just so our audience understands, this was a question is, was this an accident that he left his child in the back of the car that ultimately died of hyperthermia? Or was this a purposeful malice murder that was going on here? That's the issue in the case. And what Imran is referring to is an evidence rule called 404. And I want our audience to understand we have a law book that has the laws in it. We have court rules, which are usually much thicker than that tell us what our procedures are. But then we have evidence rules. And those evidence rules are the things that they're the guardrails of the trial. They let you know what evidence can be admitted and not admitted. And evidence rule 404 says basically it's a rule of exclusion. Bad character evidence is not admissible unless it goes to prove something like motive, intent, opportunity, preparation, plan, absence of mistake to rebut a claim or a defense. What Imran is getting to, which I thought was the number one worst thing, is that this is a devil's playground and courts are typically very cautious not to make it a trial by character association. And the inclusion of these sexual assault offenses that had nothing to do with the murder charge were completely unrelated, and case law, at least in many states, interprets that the probative value is outweighed by the prejudicial effect unless it has something that goes to motive, means, opportunity. Give me your thoughts on that, because I mean, what the judge allowed in here was just the appellate lawyers are saying character assassination to the point that there was no way then they could come to a guilty verdict because it made him look like a horrible human being.
Yeah, Bob, I agree with you gentlemen 100% as far as this being probably the most, um, when we look at all of the issues in the brief, there are some that are more powerful than others. And there's no question that this one stands out from the rest. You hit on the test, Bob. The question that we have to ask ourselves, number one, we have to ask ourselves, is this information even relevant? Once you've determined that it should be precluded, is it relevant? I, I would suggest to some of your viewers that the allegations that he was sexting people, whether that day or other days, is not relevant as to whether or not he intended to kill his child. But presuming that they're able to establish some kind of relevance, the next thing that we have to look at is whether or not the information or the allegations are more probative than they are prejudicial. And look, allegations of sexual misconduct, in particular, in this case, we have an allegation that he had an affair of some sort, however short term, with a 17-year-old. There is nothing more prejudicial in our society than crimes against minors when it comes to sexual misconduct. So the idea that the jury did not take this into consideration, no reasonable person could presume that. I did want to touch on your first question real briefly, Bob, and that is, what was powerful in regards to Dr. Diamond's the issue with Dr. Diamond. I'll tell you one thing that stuck out to me, another decision the judge made in this case that I found extraordinary was requiring the defense to produce notes that arguably were communications between the defendant and Dr. Diamond. And in my opinion, what's being set up this morning is an attempt to make an argument in the future, and they did this through their amended motion, but an argument in the future nonetheless that trial counsel was ineffective. And we have to ask ourselves, to what extent did the decision to not call Dr. Diamond, was that premised on this idea that these notes were going to be produced or at least accessible to the people? And I think that decision the court made to allow those notes, to require those notes to be produced, were inconsistent with Georgia law and could have clearly had an impact on trial counsel's ultimate decision.
Well, agree with you guys completely. Dr. Diamond, will segue into that, was an expert that the defense wanted to call with respect to memory issues, but because those notes had to be turned over, the defense arguing inappropriately, as you did, Jamie, based on Georgia law, the defense attorneys made a tactical decision not to call the expert because of that. I don't know the reason for that. I would hope that those notes would not contradict his opinion. Nevertheless, that's what they did. And by all estimations, even in this appellate brief, they're arguing ineffective assistance of counsel for not calling Dr. Diamond, but they also indicate the judge put the defense team between a rock and a hard place with regard to making this decision. Guys, I understand it. I'm a prosecutor by nature. I've done it a long time. You let the defendant have their leeway, have their day in court. Dr. Diamond did not testify now in this hearing for a motion for a new trial, the defense has been able to prevail upon the judge to say, well, we want him to testify now so that we at least could hear what he would have testified to see if that could have potentially changed the verdict. Let's take a listen to Dr. Diamond.